An objection is a formal protest raised in court during a trial to disallow a witness's testimony or other evidence in violation of the rules or evidence of other procedural law. Any attorney is able to raise an objection. There are two types of objections: objections to the form of questions and objections to testimony. There are 5 common objections under objections to the form of questions. The first objection is vague and ambiguous. A question that is unclear and has no context can be objected using this objection. The next objection is leading, which can only be used in direct examination. If there is a question which is really a statement that asks for confirmation by the witness, that is a leading question and can be objected. The third objection is compound. When an attorney asks multiple questions at a time, a compound objection can be raised. The fourth objection is argumentative. This objection can be made when attorneys argue their case through the examination of a witness. The fifth objection is asked and answered, which can be used when a question was already asked and a witness already gave an answer to it. The next set of objections are under objections to testimony. There are 7 objections under objections to testimony. The first objection is nonresponsive witness. This objection can be made when the witness doesn't provide an answer to a question. The next objection is relevance. This objection can be used if the witness's answer wouldn't be relevant to the case. Narrative is the next objection. Narrative can be used when a question calls for the witness to tell a story or the witness goes on explaining more than what the question asked. The next objection is foundation. Foundation can be used when a question is asked with no prior background facts relating to the question. The next objection is speculation, which can be used when a witness is asked to testify about something that they have no knowledge of and need to speculate in order to answer. The next objection is only used in mock trial and is called creation of material facts. This objection can be used when the witness answers with facts that aren't facts given in the case. The last objection is hearsay. When a witness doesn't speak based off of their knowledge, but rather says something they heard from a secondary source outside of court, the objection hearsay can be used. When raising an objection, an attorney must stand up and say the objection, then stating the objection they are saying. Then, if the judge permits it, they can explain their argument briefly for the objection. Your intentions must be communicated in a professional manner. The judge can rule on an objection in 2 ways. They can either sustain or overrule an objection. Sustaining an objection means they allow an objection, while overruling an objection means they don't agree with the objection and don't allow it.